Good evening, everyone. Welcome to our show, Ein Kothon. This is the 15th episode of our program. In this program, we will be discussing the intellectual property law, the aspects of intellectual property law in in our country, Bangladesh, and South Asia and whole world. We know the intellectual property refers to the intangible properties, which is opposite of the land and other properties we generally know. It has a wide-ranging legal aspects and various uh, things. There are the intellectual properties are involved with. To discuss this vast issue in a simple area and simple legal aspect, which the people of our country and the other guys can easily understand. Here we have invited our special guest, Mr. Ankur from India, who is a patent attorney, and other one is Barrister Sifat Mahmood Abdullah, and the lecturer from the East West University and the advocate from the Supreme Court of Bangladesh, Mr. Ayatul Karim. To start with our program, I'm first would like to first go to Mr. Ayatul Karim to discuss about what is IP and how the legal aspect of IP works here. Mr. Ayatul Karim. Mr. Ayatul Karim. Mr. Ayatul Karim, are you listening? Hello, Mr. Ayatul Karim. What I have said to Mr. Ayatul Karim, what does IP mean actually?
Thank you. Uh,
Uh,
so, IP means intellectual property. So, it contains property in its name. So, it's a form of property. So, there are two types of property. One is tangible property and one is intransible. Tangible property, as we know by tangible property, it can be land, it can be building, plant, equipment, or vehicles that can provide you monetary benefit. And where intangible property is concerned, it cannot be touched, it cannot be felt, but it can provide you some benefits. Uh, One example may be the inventions, and other things are artwork, literature, goodwill, brand value, software, database, recording, clippings, and so on. Since it's a property, our constitution provides right to property under Article 42. So it's a fundamental right under the Constitution of People's Republic Bangladesh. So if it is violated by any law or any government authorities, so it can be challenged by way of writ petition in the High Court Division of the Supreme Court of Bangladesh. And IP protection can be given in various ways. It may be a form of patent, trademark, design, copyright, geographical indication, or trade secrets. First, I will discuss on patents. So patents are the inventions which the government provides exclusive right to applicant. So applicant can exclusively use this patent. So he can sell or use his invention, and he can exclude others from using it. Even he can provide license to other people to use his patent. Thereafter, it comes to design. So designs are creation of mind. It can be a shape and appearance of a product, so that it makes the product distinguish from the other products available in the market. For example, if we use Apple phone sets, it is different than Samsung, Oppo, and many other phone sets available in the market.
Sets, yeah.
So by its shape and appearance, it's different from other. So even though we cannot see the name, even though we can see the brand, package, or other stuff, we can recognize it through its shape and appearance. Thereafter, it comes to trademark. Trademark is the trade name or logo.
Hmm.
It's for the identification of the owner. So when
Hmm.
we see a trademark, we can identify the trademark owner, that which company it belongs to, and owners
Trademark
use
is
it.
like business area, like for the business guys, it uses,
Yeah,
isn't
they
that?
use.
Like
Yeah,
trademarks
they
are
use
only
it.
for the business guys.
Yeah, they use
Hmm.
it to distinguish their product from others. So when we see the name, we see the right sign from Nike. So it refers to the
Hmm.
Nike product.
Hmm.
And same for when we see the Apple logo, then we may just
Hmm.
assume that it's a product from Apple Corporation.
Okay, so we
So
understood the trademarks, patents, and the industrial design. So can you just explain how the laws in Bangladesh dealing with the trademarks and the copyrights? What are the laws? What are the statutes actually? Do we have any statutes, and how those statutes are working?
okay, so in Bangladesh, the IPs are protected in various ways, and there are various enactments regarding this. So, patent and design, there are the same uh, enactment, that is Patent and Design Act 1911,
Hmm.
and the corresponding rule, Patent and Design Rules 1933. So, it provides the registration and protection of the patents and design.
Hmm.
And for trademark, we
We
have.
have a new act. It's called like Copyright Act 2009. Isn't that prevailing nowadays?
Yeah, so it's actually Copyright Act of 2000, and copyright. There is a copyright rule of
Hmm.
2005,
Hmm.
and we have Trademark Act of 2009 and
Hmm.
Trademark Rule of 2015.
Hmm.
So these are the mainly enactments, and
Hmm.
on the top of that, we got Geographical Indication Protection Act,
Hmm.
which is of 2013. It's the most
Okay.
recent enactment on
Okay.
intellectual property rights.
Before we dig into the rules and laws in Bangladesh, so we are going to Mr. Ankur Saigal to discuss about like Mr. Ankur Saigal. Can you just explain us what are the laws prevailing here in your country in India, and how the trademarks and copyrights are being protected in that country?
Yeah, thanks, Mohammed. I'd be very happy to provide some insight as to how, regarding IP protection in India. So, in India, again, you have similar kind of IP protection, like Shafat mentioned, as in Bangladesh, and it's pretty much similar globally. Essentially, if IP, as you rightly introduced, is for intangible sort of property, anything that is generated out of your intellect. So essentially, for any invention that is technical in nature, you file a patent. For any, if you want to protect just the design and not the functionality of the product, but if you want to protect just the look, you file a design application. And similarly, copyright to protect your expression, and a trademark to protect either the name of any brand, basically any name or logo that identifies with your business. You file a trademark for the same. So like pretty much globally, in India you have the same IP protection and geographical indications to protect any product that is native to a particular region within the particular country. So you have GIs for that. And that's interesting with IP, because globally the law essentially is uniform on most aspects. For example, the tenure for a patent, utility patent protection, is 20 years globally, and
Hmm.
similarly for a trademark in India, for example, the
To get
life.
that protection, I have to register as a patent, isn't that?
Absolutely,
Uh,
like registered as a patent. So,
okay.
so for a patent, the thing is that for patents are So there are two types. So in the US, for example, you call it a utility patent. That is a patent that protects the functionality of a product or a process. That's a utility patent. And then you call it a design application. That's a application or design patent, as you call it in the US. That's a patent that protects only the aesthetic value or appeal, or only the look of your product. So in
Can
India,
you give us any example about that?
yeah,
It would be
absolutely.
easy for us audiences.
Oh yeah, absolutely. So if you invented, let's say, a phone, the phone,
Okay.
for example, if you've invented, let's say, the feature of a fingerprint on
Hmm.
your particular phone, instead of entering a lock code, now you have a fingerprint. So that's a new technology, right? Where you within your phone you've embedded a technology where if I just touch my fingerprint and I add it as a recognition feature, my phone recognizes me and it's unlocked. So that is a, let's say, new invention for unlocking a phone when it was first created. So that's a good patent. Now, just the phone itself, the phone has multiple features, functionalities. So if someone created, earlier there were landline phones. So if someone created a mobile phone where it does not need to be connected to any device, there are no wires, and just you can, it's a portable device through which you can communicate. That's a invention for a patent for which you file a utility patent. But then there were phones earlier that were rectangular in shape. You had your phones that used to open up. So these are all unique designs. So for any unique technical feature in your phone or the product itself, if it is new, you file a utility patent for the same. But let's say every time I come up with a new design of a phone, it can be a circular product, it can be oval, it can be square, it can be rectangular, it can be something like your old Motorola phones where you used to flip them. So that's a unique design. So if I want to protect just the look, I can file a design application, or I can file a design application for any in the manufacturing.
Design and patent, both things are different.
They're both different essentially. So, like I said, in the US, there are in the US they're both called patents. You call it a design patent, which only protects your design, the look, and then there are utility patents that protect the functionality. In India, you call it design application. What you call a design
Design.
patent in the US is called a design application in India. But if I file a design, if I've created a new design for a bottle, for example, and if I file a design application for that in India, if I feel the US or Bangladesh or different countries are potential markets for me, I would file the same design application in these countries.
Hmm.
That same application filed in the US would be called a design patent, but that's just difference in terminology essentially. In essence, it's the same kind of IP protection that you get. So India, in that sense, has you can protect your IP by filing a patent, trademark, copyright, geographical indication (GIs), there are also plant variety patents which aren't filed as often as, let's say, other kinds of IP protection. And then it's interesting, there's trade secrets as well, which is not really a formal kind of application that you file to get a trade secret. So essentially, what happens is if you file a patent, it's published and therefore accessible to everyone in the world, right? So if I file a patent in India about a unique technology of mine, I have patent protection for that invention. However,
Do
everyone
the
in the
world
world,
has uniform patent organization where you can just from US you are patenting one of your thing and you are being protected in India. Is it possible in the whole world, or we are? I mean, do we have this type of protection
no, so you do
worldwide?
not. You do not. So patents or any kind of IP actually, patents, trademarks, design applications, they are purely jurisdictional in nature. So a patent filed in India will have protection only in India. If I want
Oh,
to file a patent, if like I was saying, if markets of interest for me are Bangladesh and US as well, then I have to file a patent separately in Bangladesh and file a patent separately in the US.
oh yes. Oh
And
yes.
it is, and the process of examination and evaluation and prosecution process of examining the patent application are independent to each country. So
Okay.
it is
With your
possible.
permission, I would like to go to Mr. Sifat Mahmood. So, Mr. Sifat, can you just explain if any Indian businessman wants to make any patent or trademark on any design applications in Bangladesh? Is it easy for them, and do we have the similar protection, legal protection for these activities?
Okay, so protection will be the same.
Okay.
Whether the individual is of Indian citizen or Bangladeshi citizen, he or she will get the same protection and same extended to legal entities as well. But if you want to file a patent application in Bangladesh, so you should file it through a Bangladeshi citizen. So you
Okay.
should any Indian citizen should file it through a Bangladeshi citizen or Bangladeshi law
Is
firm.
it possible from a law firm or, as you said, the law firm? Law firm would be the the media guy, media person.
Yeah, legal representative, right?
Okay. Okay. So
So
these things here. Carry on, please.
okay, so the difference is for Bangladeshi citizen they can file it directly or through a Bangladeshi law firm, and for the foreign citizen they should file it through the Bangladeshi citizen or Bangladeshi law firm.
Okay. So I mean, at this moment, the vaccination things are coming, the pharmaceutical patents. So if any pharmaceutical company in Bangladesh invents any pharmaceutical vaccine for corona vaccine COVID-19, so what is the legal aspect in this area? Can you just explain?
So vaccination need protection because it involves a huge amount of investment and huge human resources. So it need to be get protected by way of patent. So if any Bangladeshi firm or any institution from outside of Bangladesh, whomsoever invent a corona vaccine, they may have it registered in their country, and once they registered it in their own country, they will get protection in all the countries under the international law. But you need to file it separately in every country. The advantage of international law is you don't need to file it immediately. If you filed a patent application in one country, then you will get time. Generally, it's for a year to file it in another country. So the advantage of the international law is that it allows you time to file other countries, and if just you file it locally, then it will not protect internationally and some other countries. So you need to file different application in different countries.
I would like to go to Mr. Atal Karim. Are you here, Mr. Atal Karim? Hello, Mr. Atal Karim, are you here? Are you listening, Mr. Atal Karim? Okay. So can you just explain?
Can you hear me? I think there is some technical problem with my.
Okay, no problem. No problem.
I think there are some technical problems with.
Okay, so both the panelists are saying the patents and designs are being protected in the same country. Mr. Sifat, as a practitioner, he explains the laws in Bangladesh, and briefly, Mr. Ankur Sehgal discussed about the patent and design in legal framework in India. So, can you just explain if in any other countries, for example, the other countries like Africa, in any other countries, if the trademarks and design law and legal protection things are infringed, what are the safeguards and what are the remedies for their companies? Do you have any idea about that? And what would be the remedies worldwide? Is there any unified context, unified law, and unified treaty? Could you just explain about that? Hello.
I don't know. Is it a question to me? I have some problem with the communication.
Okay.
Yeah.
Yes.
So actually, I could not properly hear your question. Perhaps there is some problem with the technical problem with the communication. Can you properly hear me right now?
Yeah, I'm listening you. I'm hearing you. My question was that, like, if
So
any
what
industry.
was
Hello, hello.
what was your question? I actually
My question was like, uh, the trademark and design and pharmaceutical designs are protected in India and Bangladesh by filing patent application, by registering their pharmaceutical designs and pharmaceutical items. So if any other countries are like, not only the pharmaceutical things and many other things which are needed to be patented and other legal safeguard were needed. So if any other countries, though, in that countries where the things are not registered under the IP
I'm
forum.
just trying. All right. Perhaps I'm just trying to sort out the problem. I cannot properly hear, but maybe you can hear me. So I mean, uh, I don't know. The issue
Okay,
is
so
that
we
if
we
you
can waste
kindly
our time. So
maybe
can you go?
if you kindly
Excuse me,
chat.
Mr. Atul Karim. I'm going to Mr. Ankur Saigal to express his view on this matter. You know, I hope you understood my points and what Mr. Sifat Muhammad Abdullah has discussed.
Yeah,
Can you just
yeah,
explain
yeah.
your views?
Yeah, sorry. I'm really sorry for the inconvenience. I'm really sorry for the inconvenience. I cannot hear you properly. Maybe there is
Okay,
technical problem.
Mr.
If you
Atul Karim,
kindly, I mean, put the question in the chat box, maybe that would actually help me to understand your question very briefly. I would then come to the
Mr. Atul Karim,
discussion.
I'll come to
Or
you.
if
I'll
you
come
can
to
go
you.
to the other.
Mr. Atul Karim, I'll come to you in a couple of minutes. Mr. Saigal, please carry on.
Yes, yes, I did understand your question. So internationally, there are treaties to make IP protection in different countries easier, but there is no global patent as such. So, like Shifat also correctly mentioned, if you want your IP to be protected in different countries, you have to file individually in each country. Now, there are multiple treaties to make this process easier. For example, if I file the patent in India, I have 12 months, which is 1 year, to file it everywhere in the world. Now, if you want to file in multiple countries, filing a patent in multiple countries can be an extremely expensive proposition. And deciding which countries out of, let's say 185 countries, which countries you want to file in if you feel that your market is potentially huge, can be difficult to decide in such a short span of time. You may want to launch your product and see what kind of response you get before you decide which countries you essentially want to file in and spend that kind of money. So there's a PCT application you can file, which comes under Patent Cooperation Treaty, which is signed by 180 odd 160 odd member countries, if my memory serves me right, most UN nations essentially. And if you're party to the PCT, and if an applicant files a PCT application, which comes at a cost, it can be used as a route to file outside India, where instead of 12 months, you have 30 to 31 months. So you essentially have more time to file overseas. For a trademark, there's a Madrid Protocol, which is another treaty that's been signed by multiple countries. So if you file your trademark through Madrid Protocol at one point of time while filing a trademark application, you can file a trademark application in multiple countries by designating those respective countries and paying the government, which is the official fee. In which case, you don't need to pay the attorney fee in each country individually. So that's a huge cost saving. So there are multiple such treaties. There's the TRIPS agreement. There's the PCT, which is the Patent Cooperation Treaty.
WIPO.
Protocol for WIPO is essentially a World Intellectual Property Organization, which is a central body.
Which is central body, not the divisions, the central
Absolutely, but which sort of it may be fair to say that it administers most of these treaties. So, I mean, that's a fair point you make. But WIPO is essentially a body under which the PCT essentially falls. The Patent Cooperation Treaty, for example, and the
Mr. Saigal, can you just explain the world famous case, Neem case, in India? Yeah.
So I'll be happy to explain that. So essentially, in the Neem case, a European company, which is WR Grace, and USDA, which is essentially the US Department of Agriculture, they had filed a patent that was granted in Europe. And this patent essentially was for a product, for bio product, which essentially that can be used on food crops, to as consider, and it uses the fungicidal properties of neem. So this was a patent that was granted, and India opposed this patent and had it revoked in the year 2000. And essentially, this patent was revoked, and India's argument, of course, was that neem is, and its medicinal uses are known traditionally in Indian culture, and therefore awarding a patent to an applicant which is, sort of a US applicant, is not right, because these properties based on which the biopesticide was made using essentially neem based properties is something that was well known, and therefore there's no novelty to this patent. So that patent was revoked, and that was sort of a victory for India, because of course, I think it's completely understandable. People would take offense to the fact that a company in the US has earned a patent on a product that uses neem and uses its effects, and that's what they claimed as the novelty, medicinal properties and effects of neem. So that was a battle well fought and won for India.
Okay. So can you just explain any other things? For example, the agricultural patents
Sure.
is now familiar and famous worldwide. So how these things are working?
Well, so yes, essentially, patent, if it's filed in India, and I mean, I mean, agricultural patents or pharmaceutical patents. I mean, pharmaceutical patents more so as compared to agricultural patents. There's special provisions in India. For example, if at all there's a farm, and there's some popular landmark cases like the Bayer case, etc. So if at all a product of I mean, a lot of money goes into pharmaceutical research and development, all research and development, more so pharmaceutical research and development. And therefore, I think it's completely fair for a pharmaceutical company to claim a patent and monopoly over the formulation they've created, and, the medicine that they're essentially providing. What happens is, if this medicine, let's say the demand for such a medicine in countries like India or Bangladesh that are densely populated countries, the demand is very high, and the supply that the company that owns the patent, the supply is, they're not able to meet the demand. In that case, there is a provision for compulsory licensing, where the company is essentially obliged to license this patent to other companies, so that other companies can manufacture and meet up with the demand. Or if, let's say, if it's a life-saving drug and the drug is priced extremely high, there again, there's a provision where there can be a compulsory license, authorized from the court, in which case the patent needs to be licensed. Or if a patent is held by a pharmaceutical company and they're just sleeping on the patent and not commercializing it, and if there is a need for that product in the market for as an important medicine, then there's again provision for licensing. So I mean, there are special provisions for for pharmaceutical industry, for example.
Exactly. I would like to go to Mr. Sifat Mahmood Abdullah. Mr. Sifat Mahmood Abdullah, could you just explain and could you just give your remarks on that? Like, for example, Mr. Ankur Sehgal, the panelist from India, he has said many things about the pharmaceutical patents and agriculture patent things, and how the things are working in India. So you have worked with many treaties. You traveled many countries to join in their treaties and organization, and many seminars in worldwide and in abroad. So can you just explain us? The question is a simple, but I can explain without taking any country's name. For example, if any patented and trademarked and branded things are confiscated and wrongly produced by any other countries, the many countries, they wrongly produce, they change their brands and they put their own name. So for this type of infringements, for this type of thefts, do the world treaties and any the organizations and like WIPO and any other agreements and any other seminar, do you have any other protection worldwide So can you just explain my large question in the short
Okay, I
form?
can sum it up. Okay, first I want to add something what Mr. Ankush just said. Bangladesh situation on pharmaceutical patent is different. So Bangladesh is a least development country as specified by in the TRIPS. So pharmaceutical
Tips,
patents are
tips.
not
Can you just
granted in
explain the
Bangladesh.
tips things for our audience? Tips. Hello.
Hello.
Can you
So
listen me?
it's trade-related aspects on intellectual property rights.
Hmm.
So it divides the world, all the countries of the world in three parts. So one is least development country, and one is developing country, and one is developed country. So
Yeah.
Bangladesh is currently in least development country.
List.
So the TRIPS made provision that in order to people of the less development country to the medicines, so in wide range, so they allowed the least development country to hold their IP protection rights for the other firms for a time being. So it's currently up to 2033. If Bangladesh just shifted to the new category, let's it's developing country,
Developing. Yeah.
developing country. So then it need to implement the patent policy at once, so within 6 months or something like that. So the government need to initiate the process of removing the mailbox system which currently operating in our country if it is developed within few years or by 2033.
Okay. So if it's
And
Bangladesh, carry on, please. Carry on.
There are some international conferences going on, organized by WIPO, that is World Intellectual Property Organization, and there are many other organizations, that is International Trademark Organization or Asian Patent Attorneys Association. So they are mainly regional or worldwide. So they are mainly just working as a bridge between the trademark owners, trademark attorney, and other stakeholders.
Okay, look,
So
Mr.
that
Mr.
the
Sifat, I would
cooperation
like
between
to
them.
say you one thing. Bangladesh is a least developed country, isn't it? Like least developing country. Which one?
Bangladesh is currently a least developed country.
Least developed country. So Bangladesh will be, people of Bangladesh will be getting the protection of this IP law safeguards when it goes to the developing countries list. When it's climbed to the developing countries list, isn't that? Or
Yeah,
before that, we will not be getting any, IP protection. Isn't that?
no, being
Are you
less
saying?
less developed country, Bangladesh is not granting patents to the foreign companies. So to make the medicine available to its citizen, because when you grant patent to the foreigners, so the medicine price will go high, and they will not able to distribute it with the vast amount of population in
So
Bangladesh.
I would like to go to
So
Mr. Ankur Sehgal.
one thing may be done
Ankur,
here.
excuse me, Ankur, can you just explain on his point, like how about the India situation on that thing?
In what regard again? Can you just give me the context?
He has said like the Bangladesh is the least developing countries, and it is not by giving any patents registration to foreigners for the pharmaceutical drugs or anything. So what about the position in India?
India actually does give patent protection to, for foreign sort of drug manufacturers. And India is, of course, a very important market for all the large pharmaceutical companies. So, all patents that come out of these companies, that are filed by these companies globally, do enter India. However, as I had earlier mentioned, there are provisions in the Patent Act, under the Indian Patent Act, that do provide some respite and relief in case of pharmaceutical drugs, and more so crucial and important pharmaceutical drugs. like, if at all the need arises, or if a foreign company has a patent, and therefore due to the patent, Indian drug companies cannot manufacture that product, and the company is not the overseas foreign company is not commercializing the drug, they are bound to commercialize, to license out this patent, to compulsorily license it out. So it is not something that is at their will, but compulsorily they are asked to license the patent to an Indian company for manufacturing, either if they're not commercializing it, or they cannot meet the demand, or if at all it's a life-saving drug that's priced too high. So, I mean, there are provisions in the law, but of course, overseas companies can file patents in India in the pharmaceutical space, unlike the situation in Bangladesh, as mentioned by Mr. Shifat.
Okay. So, I mean, before we conclude our program, before we go to, I would like to talk with Mr. Sifat Mahmood Abdullah. You have, I mean, from both of you, we have learned many things from about IP and trademark design, patents and logos and everything. So, in a brief manner, can you just? So, my question before we conclude. So, like you both, working overseas on the IP law and regarding the patent things. So, you have found many loopholes in the law and many difficulties in the registering process. I mean, I don't know. I'm not, starting that you have already found the problems and difficulties. So, if you have found, and can you just explain what are the problems in registering and using the IPs worldwide, and how to solve this problem? I would like to go to Mr. Sifat Mahmood first, and then I'll go to Mr. Ankur. Can Sifat explain us what are the problems and what can be done?
Okay, so for that, we extremely need the enactment of new.
Hello. Hello. Serious technical difficulties, So we need to solve
Called
this thing.
Indian subcontinent. So I think that India has enacted new law, but for Bangladesh is still the same.
Sifat, Mr. Sifat, we couldn't understand, the similar technical difficulties before you go to IP difficulties. So can you just explain the things from the beginning? Say again.
Okay, can you hear me now?
Okay, carry on.
Can you hear me now?
No, yes,
is it okay?
Yes, it's okay. Hello.
Okay, so what I suggested before, that we need enactment of a new patent legislation. Just because our patent law is more than 100 years old, it was enacted in 1911. So it was same for Bangladesh, India, Pakistan. I mean the Indian subcontinent, but the other countries have changed their laws, but Bangladesh didn't change its law yet. So we are just running on the just pick and mix theory, so that we are using international law, that is like TRIPS agreement, and we are filing under the priority provision of the patent cooperation treaties, and we are using the provisions of the Paris Convention. So currently it's the pick and mix situation. So just we need the new patent law, which is under drafting stage yet. So the
So
training
you are
of
talking
judges
about
and
the
examiners
patent
is
law in
highly
Bangladesh,
required,
isn't that?
because
Mr.
yeah, it's talking.
You're talking about Bangladesh,
Yeah,
and
patent law in Bangladesh.
we are waiting. Like you will be discussing the problem about the Bangladesh and the world. Can you just explain? Like we can bridge up your things with Mr. Ankur Saigal. You got my point?
Okay.
Okay. So the problem,
shall I carry on?
Yeah, carry on.
Shall I carry on first? Then the Ankit may have a say on it. Okay. So another problem is that the training of the judges and examiner, because the patents are highly technical, that it need to be a completely new one. That is, that it required to be novel or there should be inventive steps. So it requires to the science and other technologies. So the training of judges is needed. So that we have the example of Orthorin Adalotain. The judges are trained, are just specified in one topic. So the training of judges is required, and they should attend the international conferences so that they make the Bangladesh system compatible with the international system. And also digitalization of the IP office is required, because when you want to register your company, you can search the name digitally. But for Bangladesh, it's still manually. One cannot directly search it in the system. So I think the Bangladesh Patent Office is working on that, but it needs to be digitalized very soon. And also the punishment of the IP protection is very less. I think it's more or less 2 years imprisonment, and fines are maximum 3 lakhs taka. It need to be increased, because patents or IP rights, these are highly valuable. I want to give you an example that the GlaxoSmithKline's well-known brand, about Holrix and Boost. They sold their drinks and refreshment part to Unilever, Hindustan Unilever, and the deal amount was 3.8 billion. So IPs are highly valuable, and if the punishment or penalty is so less that it will not give the protection for that valuable properties. So increasement in the protection.
Hello, Mr. Sifat. Mr. Atal Karim is here with us. So, Mr. Atal Karim, are you listening the whole program? And you sometimes at some point you are away from us. Hello.
Hello.
Hello. Yeah. Mr. Atal Karim. Mr. Ayatul Karim, we are not listening you. Not at all.
Yeah, I think I'm clear right now. I can listen to you. Can you listen to me?
Yes.
Yeah, please go ahead.
I would like to, can you just explain us in a brief, the overall situation in the world and in Bangladesh and India? We have panelists from India, and you being a lecturer, can you just explain from the academic point of view, like what are the problems in IP nowadays, and how can we solve those problems and difficulties?
All right, thank you very much for giving this wonderful opportunity, and I'm really apologizing for not being able to be connected properly with you. And I also like to thank other two guests of the panels. My full point is that perhaps we can agree on one point, that the intellectual property is principally is a kind of a domestic and territorial protection, or some kind of enforcement in the territorial nature. So the problem and the prospect of intellectual property, if we want to say, that is basically varies because of the jurisdiction to jurisdiction. You will have kind of a prospect in a developed country. The same kind of a prospect we cannot expect from the developing country or the least developing country. So a country like Bangladesh. Also, the challenges are also different because of the situations of the country. We must remember one thing, that there are certain kinds of variables that are involved with the protection of intellectual property. So intellectual property is not itself is a one kind of issue that is independently, will thrive on a particular country. If other variables, for example, digitization, for example, awareness, for example, education, for example, the market, for example, consumer, if the other variables or the indicators are not properly being there, we cannot expect that intellectual property per se, as a subject matter, it will thrive in a particular jurisdiction. So, from my perspective, I would say in Bangladesh, the common problems are in the developing countries or the least developing countries we know. In Bangladesh, we know that we have less type of awareness in case of intellectual property. We have less, significance in terms of the education of intellectual property in Bangladesh. also as a separate branch.
Nowadays are
Yeah, it is
developing.
not.
Like previously, Bangladesh
Yeah,
got
now it is.
independence,
Now it is.
not
Yeah,
not
of
like
course.
50 years back. Nowadays, it's
Yeah,
like
yeah,
going
yeah.
developed.
Nowadays we are going.
Hmm.
Yeah, nowadays we are going ahead. At the same time, if you think about, like, for example, in the current situation, what are the challenges of the intellectual property worldwide? That is one we say we can understand, that is that digitalization has affected in many aspects. Of course, intellectual property has been also another aspect which have been affected by the digitalization. For example, online infringement, or I mean other issues relating to the digital media, that has been a kind of a challenge for all the countries, not only developed countries, but also the developing countries as well. So my conclusion would be like in a simple way, that we cannot conclude in a very silver lining. I mean, in one sentence, that what are the challenges and prospect of intellectual property in every aspect, every country. That depends upon the situation or economic condition or overall legal framework, awareness, and other related issues of a particular country. So we can conclude in that way. So in my point of view, Bangladesh is right now is doing well in terms of going ahead with the intellectual property. Protection. For example, we have industrial property protection under the DPDT, which has given registration of industrial property, and we have another branch of another office under the Ministry of Culture, that is the Copyright Office, that is giving the protection of the copyright in Bangladesh. And in both ways, and even recently in 2019 we have another law, this new law, that is the Plant Variety Protection Act, which has created another type of independent body which will give the protection of plant variety for the farmers or the breeders in Bangladesh. So I can say that yes, overall legal climate in Bangladesh is good. Now we are going into the right direction, but still we have to.
How about you are talking
Yeah.
about the Bangladeshi law,
Yeah.
and how about
Yeah.
the situation in the international
Yes.
country about it?
Yes. All right. If I want to say a few words about the world's situation right now, actually, that in worldwide intellectual property, particularly in the developed countries, the industrial property, for example, those property which called patent, trademark, industrial design, or trade secret, this kind of industrial property that have given much more importance to the other parts of the world. That part is basically the developed world. Okay. In another part of the world, which is developing world, they are giving the importance to the industrial property, but at the same time they are giving importance to the other sets of property. For example, traditional knowledge. For example, traditional medicine. For example, in case of the India, if we say India has developed so much in case of the traditional knowledge of traditional medicine and other things. If you think about the European Union, they have given importance. They are giving importance to the basically to the industrial property. They are giving importance to the trademark, patent. They are giving importance to those areas. But if we think about like USA, same goes with the industrial property, and also they are giving importance to the copyright law as well. So this is we can say that in developing countries they are giving importance to those areas. But at the same time, they are giving importance to some of the, for example, European Union, they are giving importance to the geographical indication, protection of geographical indication as well. And other parts of the developing countries or the least developing countries, they were actually in prima facie, they were skeptical about the intellectual property. They think about the TRIPS agreement and other international instrument might take away the rights of the developing countries people, and might not protect the interest of the developing countries or the least developing countries. So now they understood one thing, that we cannot be out of the market because we are the member of the WTO. So we have to compete in the market, and we have to include within the market, within the world trade. So therefore, they have given importance to industrial property as well. At the same time, they are giving the alternative to the other forms of intellectual property, as I mentioned, traditional knowledge, geographical indication, because the culturally diverse countries are mostly developing countries and the least developing. For example, if you think about the African region, that African region is basically enriched with the traditional knowledge, enriched with the geographical indication, enriched with the biological diversity. So they are giving importance to those areas as
So,
well.
Abdul Karim, we have reached the end of our program. So
right.
before conclude, I have talked with Mr. Sifat Mahmood Abdullah and you. And before conclude, I would like to go to Mr. Ankur Saigal to discuss about two matters, and we will conclude. Mr. Ankur Saigal, for the first thing, you might, you are requested to discuss is like if any artistic work is uploaded in YouTube, the YouTube and online forum, and how it's these things are being protected. And as the same question I asked to Mr. Sifat Mahmood Abdullah, and you are requested to answer the same question about the how what are the problems worldwide and how can those problems be solved. Please, Mr. Ankur Saigal.
Sure. Well, so if any artistic work is uploaded on a public platform, the ownership of the work is absolutely clear by the person who's uploaded it. And if any third person makes use of that work for any commercial gains, that will be infringement. Considering copyright is essentially protected by common law. Uh, Having said that, it's always advisable to file a copyright application if any of your artistic work you feel is commercially important to you. That makes it easier to prove in a court of law, just in case of a contentious matter, that this is copyright owned by you, and it saves you the trouble of essentially proving that this copyright is owned by you, essentially. However, if any artistic work is owned by someone and they've uploaded it online, the work is owned by the person who's created the work. And any infringement of that or any usage of that artistic work for any commercial gain, would essentially mean infringement. So that's where the situation stands as far as artistic work. Also, it really depends on the terms and conditions. So there are multiple digital platforms available right now where users can put up any kind of information based on what the platform essentially is for. In such a case, of course, we accept everything. No one has the patience or takes the trouble to go through the terms and conditions, but everyone does have their terms and conditions. And now with with the Facebook fiasco and issues pertaining to security and privacy, GDPR, which is Global Data Protection, has become extremely important to ensure that privacy and security of data online is taken care of and well protected. So, I'm sure very soon we'll be seeing most countries complying with GDPR regulations.
And as I asked the second question to Mr. Sifat Mahmood Abdullah, what are the problems, in IP arena, and what could be done at those points, like to make these things safeguarded, like I artistic things, the business guys, their initiatives safe and protected worldwide. What can be done? Can you just explain? And can you just give us any? Excuse me, Mr.
Recently,
Ankur Saigal.
Bangladesh is developing.
Yeah, and I
In
asked
the
this question to Mr. Ankur Saigal. Can you just explain?
Oh, I'm sorry, that question was for me.
Yes.
I'm sorry, could you please summarize it?
Yes.
I'm sorry, I missed.
Okay. And what are the worldwide the problems worldwide, and what could be done?
Sure.
Yeah.
Well, so, you put me in a tough spot when you asked me what the problems worldwide were. Maybe I can speak more, in the Indian context than worldwide, because of course, with when you talk about business, sort of businesses going global, the relevance of geographical boundaries are sort of gradually, the relevance is decreasing, considering businesses going global, and therefore IP protection and having, definitive and clear mechanisms to enable IP protection in different parts of the world for patents or IP arising in a different country is extremely important. And I think WIPO has done a fairly good job at creating such mechanisms and clearly defining how to efficiently protect your IP in worldwide through various treaties in place. So I think they've done fairly fine. As far as India is concerned, I mean, to be very honest, there were multiple issues earlier, which is why if you would look at patents, for example, being filed in India, were majorly filed by overseas entities, and few Indian entities were really filing patents. That's changing. And now more Indian companies are filing patents, considering better enforcement, of course, and also considering better timelines. Earlier, it would take very long for a patent to be accepted, from filing to, let's say, grant or refusal till when it reaches a logical conclusion. It would take an embarrassing amount of years in many circumstances. However, over the years, the situation become extremely good, and the patent office. I mean, they've hired a new set. New examiners, the process has become efficient, timelines are being reduced, there are multiple benefits being provided to startups and smaller entities in terms of cost saving and schemes for better IP protection at cost effective rates. So I must say that the Indian Patent Office and the Indian IP Office has done a fairly good job for IP protection, and we're seeing patents being granted in as less as 8 to 10 months, which is quite amazing, even from a global sort of standpoint comparison.
Mr. Sifat Abdullah has said like the some difficulties in our statutes and then our acts regarding the trademarks and copyrights act, for example, the penalizing things, less financial, less less penalty for the infringement of copyright and patents design. Do you have the same things in India prevailing, or you have the better things? Can you just explain us?
Well, I mean, compared to what Mr. Shifat said, I mean, the situation in India is definitely much, much better. As I mentioned earlier, there was a serious issue as far as getting interim injunctions are concerned, or, maybe the timelines for getting a patent or a trademark. So now it's become really good. I mean, trademarks are accepted in as soon as 3 to 6 months many times, and can, of course, basically, if the prosecution gets complicated, can take longer as compared to earlier when it take much longer. I mean, there are multiple sort of litigations that happen in India in the pharmaceutical space and the telecom space in all, and we've seen huge amounts of money being exchanged as patent infringement damages. So, I mean, as compared to what Mr. Shifat was saying, where the amount is as minimal as 3 lakh Dhaka, I mean, in India, of course, it's completely dependent on the case being presented and damages being presented based on a loss due to theft of intellectual property or infringement of IP. So I think, of course, it's case-to-case basis. And I think India in that context is, as far as damages are concerned, or as far as, the scale of some fairly large litigations, India is at par with, some very well-developed countries in the US and in Europe as far as enforcement is concerned.
Thank you, Mr. Ankur Saigal, for giving us your valuable time. And we are at the end of our program. Thank you, Mr. Sifat Mahmood Abdullah. Thank you, Mr. Atal Karim. And we would like to say sorry to you, Mr. Atal Karim, for our problematic connection. Thank you, our panelists. And we would like to finish our program for this day. And the audience, you are requested to see our next program on Tuesday. Thank you very much. Good night for today. Goodbye.
Thank you. Thank you. Thank you, everyone. Bye.
দাম দিয়ে কিনেছি বাংলা, কারোর দানে পাওয়া নয়।